Hello everyone, welcome back to our channel. In this series of video, we are going to discuss about Module 3 question bank with set of answers. And this is 21RMI56 Research Methodology and Intellectual Property Rights. Come, let's go into the video. First question, summarize the conditions that must be met to obtain patent protection and how do these conditions vary across different jurisdictions. So to see the answer for condition that must be met to obtain patent protection is these are the three conditions. That is, when you are applying for a patent, we have to ensure that it is a novel creation, innovative creation, and you have to check whether you have followed the inventive steps. That is, it doesn't match with any of the existing technologies. And then third one is capable of industrial application. Like you have done a creative novel idea that matches with industrial application, what actually the industry needs, so that we can sell the patent to the industry. So these are the three conditions that has to be met for the patent protection. And here when you see the jurisdiction, you have three: northern, southern and western. So these are the different states where you can submit the patent application. So it comes under different jurisdiction: northern, southern and western. So based on the residential area where we live to submit your patent application, that jurisdiction will be selected and applied for patent. Next question, examine when should an inventor consider patenting an invention and what are the rights associated with patents once granted. So for the first question, when should an inventor consider patenting an invention? So the owner of the invention should, if he or she is expecting some monetary benefits, money out of the invention, then one can submit for patenting. So if it is for monetary benefits, there are two kinds of things that can be applied. It can be applied. One is trademarks and another one is patenting. If you go for trademarks, you will have more number of year, more lifespan will be there for you. And if you are going to patent, then you will tell that invention will have only short lifespan. So you're going for patenting. What are the rights associated with patents will be, the patent owner will have the rights to decide whether it can be patented or it can be trademarked or it comes under some other application process. The owner has to decide it. And then the invention cannot actually be commercially made, like importing, exporting, distributing. You have to file the patent, then you have to go through examinations, all the scrutinies done by the appellate board, then only somebody can choose whether the patent can be granted. And the patent rights or negative rights, that is, if suppose there is any implication that is happening, infringement that is happening, the patent rights can produce a negative impact for it. And if suppose it is illegally used by some other people other than the owner has all the rights to compensate, give compensation for the, that is, ask compensation for the person who has used his own patent in a different way. Yes. So moving on to the third question, explain the process of enforcing patent rights and legal implication of the patent infringement. So process of enforcing patent rights is nothing but we have to abide by the laws, regulation, rules, standards and social norms. Like we have to submit a process, file the patent and then go for the scrutiny process like examination, jurisdiction will review. If suppose if there is any claims, we have to answer for those claims. All those should be done. Then it should be enforced completely by the judicial powers. So they'll be completely monitoring, identifying and they'll take action if suppose if there is any infringement occurring on that particular patent. Then what is the legal implications of patent? Legal implication is, if suppose if there is any infringement, they can inject your patent. That is, they can stop your patent from the usage, or they can claim that there is some damages, or you can claim for profits, or completely it can be told that the patent cannot be used any further. And fourth one, demonstrate the types of invention eligible for patenting and some examples of non-patentable matters. So types of invention eligible for patenting will be in any kind of novel creation, invention in any field. So for example, I am quoting penicillin. So penicillin have first generation, second generation, third generation and fourth generation penicillin, and these are the different day-to-day items that is being patented by many people. Toothbrush, toothpaste, shoes, all these are patented products. The products that cannot be patented is nothing but the traditional knowledge that we follow from right from our grandmas or grandfathers age, that cannot be patented. Plants and animal creation cannot be patented, or musical work cannot be patented, artistic work cannot be patented, musical artistic works can be copyrighted but that cannot be patented. Moving on to the next question, illustrate the steps an inventor should take to avoid public disclosure of an invention before patenting. So why actually disclosure is important is we have to ensure that the patent registered remains in our name and no infringement occurs. So to safeguard our patent, we need the disclosure. So non-disclosure agreement can be signed. That is why we tell that it is important. So the steps is nothing but you have to either publish or publicly display that it cannot be patented. It can be patented. But before patenting, you should avoid all this public disclosures. Like you cannot publish or tell somebody that this is happening. And then there is the Patent Act, which will provide 12 months grace period. The date you file the application, you will have 12 months of grace period. Either you can do modification, or if suppose client comes, you can answer the claims, or even you can remove the patent from filing. And then disclosure of invention before filing a patent application will be unavoidable. This is one of the important things you have to go through. You cannot avoid it. Next, outline the process of patenting, including prior art search, choice of application, filing procedure and examination. So this is the portal that you can go and log in for filing a patent, and then you have to publish your patent regarding the methodology, and then examination will be done by the appellate board, and then the grant of patent will be done. So prior art is nothing but it is the information that will be lying, that once it is published, it will be lying in any form, in kind of a paragraph, in kind of a research paper, article paper, it will be lying, so that prior to date some invention can be known that this is being done. That is prior art. So this is the process that is carried out for filing the patent. Hope you have understood the concept. Stay tuned for more information. Thank you.